Good evening, Section Z. Tonight we're going to look at the end of Chapter 10 in the Duke Mayer text that deals with common interest communities. So this would be things like condominium associations or planned subdivisions. The restatement third has a definition. It says the distinctive feature of a common interest community is the obligation that binds the owners of individual lots or units to contribute to the support of common property or other facilities, or to support the activities of an association, whether or not the owner uses the common property or facilities or agrees to join the association. The authors tell us on 554 and 55 that the rules about servitudes generally apply to common interest communities. They suggest that if you are trying to decide whether privity exists, privity requirements are generally going to be satisfied because the developer of the common interest community will be in privity with each of the original purchasers of units or lots, and then those purchasers or of individual units or lots will be in privity with the successors who purchased from them. If you have issues about touch and concern, if it's a negative restriction, generally you're talking about a restriction on the use of the property, and so it probably does touch and concern the land. With respect to affirmative covenants, these have to do with paying dues or money for some purpose. And if it's paying for a homeowners association, that has generally been held to touch and concern the land. So the case that they give us to look at this idea is the Narstedt case from California over on page 555. And so here we have a condominium restriction that restricts animals, including cats and dogs. And so we have an individual condominium owner who lives with her 3 cats. The homeowners association or the condominium association finds out that she's violating their rule against cats. She says it's not a problem. Her cats are noiseless. They're not a nuisance. They don't create problems for anybody else. But the association starts levying fines because it's violating their rule against owning cats and dogs in your condominium unit. And so the California law on the subject tells us that top of 558, that under a California statute, restrictions contained in a recorded condominium declaration will be enforced unless unreasonable. So in other words, they're kind of presumptively valid, and then you have to show that they're unreasonable to prevent them from being enforced. Now, the California Supreme Court here relies upon cases from other jurisdictions like Florida and Massachusetts to draw a distinction between where a particular restriction is found. And so if a restriction is found in the original documents that created a condominium association, then they are more likely to be enforceable than if they are restrictions that are adopted later on by like a condominium owners association. And basically the reason for that distinction is that presumably you've got universal consent to anything that is in the original documents creating the condominium. Anybody who was an original purchaser or who bought one of the units in the condominium presumably would have found out about those particular restrictions, and by agreeing to live there had effectively subjected themselves to those restrictions. That isn't necessarily the case for some rule or restriction adopted after the fact by the condominium association. Those might not be the subject of unanimous consent. So in deciding whether this particular restriction is valid, over on page 559, the court adopts a standard saying that they'll be enforced unless they are wholly arbitrary, violate fundamental public policy, or impose a burden on the use of affected land that far outweighs any benefit, which is a standard that they apparently borrow from the law of equitable servitudes. But it's a very deferential standard. It's one that makes it likely that a particular restriction will be enforceable. And the California Supreme Court thinks that's a good thing. They think that it's beneficial to people who buy into condominium units, that they can have some stability and security in knowing that the restrictions that are imposed on the condominium association are going to be enforced. There will be less kind of costly litigation, fewer cases clogging the courts, and it allows the homeowners association to make a blanket determination, a policy decision that will apply equally to everybody, instead of having to engage in a kind of a case-by-case analysis of whether particular activities of particular landowners or unit owners should be restricted. Now, the California Supreme Court here rejects the analysis relied upon by the Court of Appeals, which had based its decision on some earlier appellate court decisions, one called Bernardo's Villas and one called Portolos Hills. One of the cases had to do with a ban on trucks. The other one had to do with a ban on satellite dishes. But in those appellate court cases, the courts had said, well, you have to look at the restriction as applied to a particular landowner. So you can't just blanket ban all trucks. You got to look at the particular truck and the particular truck owner and see whether it's reasonable to ban that truck from that subdivision. The California Supreme Court thinks that that's not how you should look at questions of reasonableness of a restriction. Instead, you should be looking at whether a restriction is reasonable in general. And if you decide that as a general matter it's reasonable, then it can be applied to individual unit owners without taking account of their individual differences in circumstances. And so I guess the idea here is they don't want to have a homeowners association kind of making case-by-case determinations about, well, your cat, it can stay because it's not noisy and it doesn't cause any problems, but your next door neighbor's cat, that has to go because it yowls at night and smells bad. One policy question you might think about is, do common interest communities give people too much control over the lives of their neighbors? It's kind of a libertarian nightmare in some ways that your condominium association or your homeowners association can adopt a restriction that you're required to live by. Maybe libertarians shouldn't live in common interest communities. Maybe that's the solution. But, I remember reading about a case in Atlanta where there was a residential subdivision that had some restrictions on the individual homeowners, and the homeowners association was fining one of the owners of a unit or a lot in the subdivision because their grass stayed green during the winter. And apparently the restrictions required everybody to have the same kind of grass. It was a kind of grass that turned brown in the winter. And so when one lot owner's grass stayed green in the winter, the neighbors got upset and the homeowners association started imposing fines. Notice page 564 after the case that the California legislature, after this case, was persuaded that this kind of thing should not happen again. They enacted legislation that says no governing documents shall prohibit the owner of a separate interest within a common interest development from keeping at least one pet, including a cat, dog, etc., subject to reasonable rules and regulations of the association. So I guess the homeowner or the condo owner here could have kept at least Boo Boo, but she might have had to get rid of the other two cats if the condo association wanted to keep everybody limited to one pet. Now, note 2 after the case talks about how the third restatement deals with restrictions like these. And it says that there's a presumption that this kind of a servitude is valid unless it's illegal, unconstitutional, or violates public policy. And then they kind of go further into defining that. They say it violates public policy if it is arbitrary, spiteful, or capricious, if it unreasonably burdens a fundamental constitutional right, if it imposes an unreasonable restraint on alienation, an unreasonable restraint on trade or competition, or it's unconscionable. But they distinguish that approach from the approach taken by the California Supreme Court in this case. Note 3 on pages 564 and 65, the authors point out that some states have applied the business judgment rule to at least some decisions made by the board of a homeowners association or a common interest community. So what's the business judgment rule? This is something that comes to us from the law regulating corporations. Basically, it is the standard that courts use when they evaluate decisions made by a corporate board of directors on behalf of the corporation. And it's designed to be deferential. It gives a level of discretion to the directors to act on behalf of the organization. Decisions are upheld if they exercise their discretion in good faith after reasonable investigation and in the best interests of the association and its members. Note 4 on page 565 deals with servitudes that have been invalidated on the ground that they amount to illegal discrimination against protected groups. And so a famous case that you may have looked at in your constitutional law course, Shelley versus Kramer, the US Supreme Court decided that restrictive covenants in a neighborhood barring sale of houses to non-Caucasians was a violation of the Equal Protection Clause. More recently, those kinds of decisions would probably be rendered not under the Equal Protection Clause because there's kind of a tricky state action element there, but would be decided under legislation, either the Fair Housing Act, which was passed after Shelley versus Kramer, or the Civil Rights Act of 1866, which was passed before Shelley versus Kramer, but wasn't interpreted to apply to private discrimination until after Shelley versus Kramer. The case they give us here in the note, Hill versus Community of Damien of Molokai, has to do with another kind of recurring situation. Here, there was a neighborhood that had covenants restricting housing to use for single-family residences. And there was a nonprofit that had purchased a home in that neighborhood, and they were using it as a group home for 4 AIDS patients. And so those AIDS patients were living in the home, and there were caregivers coming to provide services and the like. And so the neighbors are trying to enforce the restriction to single family use, saying that for unrelated people living in the group home, that's not a single family use. And the nonprofit that runs the group home is defending under the Fair Housing Act, claiming that enforcement of the restriction in this context would be a violation of the restrictions on discrimination based on disability. The court decided that enforcing the covenant in this context created a disparate impact on people who were subject to a disability, and that there wasn't enough reason for the neighbors to enforce the covenant, that it was a reasonable accommodation for them to allow the group home and not enforce the covenant as strictly as they were trying to do. Now, on page 566, the authors move on to different kinds of common interest communities. We've talked about condominiums already a little bit, but condominiums, basically, you're talking about a situation where there are lots of individual units within a single building, and each of the individual units is owned separately by a particular owner. But the exterior walls, the land underneath the building, the hallways, the common areas, those are owned as by all of the unit owners as tenants in common. And typically each unit is owned separately, so each unit owner might have their own mortgage. They might have to pay their own real estate taxes, but they also might have to contribute to some condominium association, which would maintain the common areas on behalf of all of the owners. The authors also talk about another arrangement that you find in New York in particular, cooperatives. Here you've got a building with lots of units in it, but what the owner of the building is a corporation, and the individuals who have residences in the building are shareholders of the corporation, which is run by a board of directors. And each one of the residents has a long-term lease of their apartment unit. Financing commonly works differently in this situation. With a condominium, we said that each owner of a unit would have a separate mortgage. So if my next door neighbor isn't paying their mortgage, doesn't really have an impact on me. I have a separate mortgage. But in a cooperative, there's kind of one mortgage for the whole building. And so if one person isn't paying what they're supposed to be paying, then others have to step up and make up the slack. And so there is screening of the financial wherewithal of potential residents to make sure that they are a good risk, that they are likely to be financially stable and help pay their fair share of the common expenses. So over here on page 567, they say in a common interest community, the developer imposes the following restrictions, and they ask which, if any, are invalid under the restatement third of property or under the Narstedt version of the reasonableness requirement. Some of these have clearer answers than others. I think they just wanted you to kind of think about different kinds of restrictions that might be applied in a common interest community and how a court might analyze them depending upon what legal standard they're applying. And so the first one that they mention is here, no flag of any kind, including the American flag, may be displayed. The authors wonder, would this be under the restatement standard an unreasonable burden on a fundamental constitutional right? The authors think that maybe that would might be a likely holding. Similarly, under Narstedt, the question would be whether it violates fundamental public policy. They think you might reach the same result there. There's actually now a federal statute that that restricts condominium associations from putting too many limits on displays of the American flag. The Freedom to Display the American Flag Act. You can have reasonable time, place, or manner restrictions, but you can't just kind of ban flying the American flag under that statute. Question 2, you can't have any sign except a house location number, and you can't have any Christmas lights displayed outside of a house. The signs, the authors say, well, maybe that would be deemed unreasonable as a burden on your freedom of speech and therefore violate your public policy. For the Christmas display, they note this, the case Osborne versus Power, case out of Arkansas, decided under nuisance law. That was where there was somebody who really, really liked Christmas lights and had just a kind of a spectacular Christmas light display. And it became a problem because everybody wanted to come see this person's Christmas lights. And so the whole neighborhood was filled with cars throughout the holiday season, driving slowly past and tying up traffic so that the neighbors were having difficulty navigating in their own neighborhood. And so in that case, the Osborne case, the court decided that it was a nuisance and required the person to cut back on the lights. Don't have to get rid of them altogether, but you can't have so many that everybody wants to come see them. The third restriction here, no solar energy device shall be installed on the roof of any house. The authors here think that there's a public policy of conserving energy that might weigh in favor of allowing solar devices. On the other hand, some people think they look ugly and might not want them in their neighborhood. They think that they could see more decisions possibly in the future upholding solar energy against that kind of restriction. I think I was reading not too long ago that they are developing new forms of solar equipment that it's just basically like shingles on your house that are created so that they absorb and collect solar energy. So maybe that is a solution to the problem, is that it will be possible at some point to have solar energy units that don't look like they're solar energy units. Fourth, no house shall be used to provide daycare for non-residents of the house. They tell us that the Woodvale case, which is cited here in the note, held that it's not against public policy to prohibit use of a condominium unit for daycare providers. And there are other courts that have agreed that that kind of a covenant could be enforced. Number five, no religious services or activities of any kind are allowed in the development's auditorium or any other common areas. In that case, there was a state law that said that you could, that you could not unreasonably restrict any unit owner's right to peaceably assemble. But here in that Florida case, the court decided that banning religious services was not a restriction on the right to assemble generally. It just was for a particular purpose, and so didn't violate the Florida statute in that case. Six, a ban on outdoor clothesline and clothes drying. They cite to an Ann Arbor newspaper article. And so, you know, would this be permissible? You know, kind of competing public policy concerns. On the one hand, you know, you're using less energy if you're drying your clothes outdoors. On the other hand, you know, some people might not like the look of clothes flying in the wind and prefer to enforce that kind of restriction. Seven, no signs of billboards or advertising without prior approval by the Architectural Control Committee. And they talk about a particular resident placing a Christmas wreath with a peace symbol on the door, and the Architectural Control Committee orders that it be removed. Architectural control committees are basically designed to control you know, kind of aesthetics within a place, to make sure that if somebody is kind of, you know, painting or kind of changing the appearance of their facility, that it looks consistent with the way that the whole common interest community is designed to look. The authors think that you know, that this kind of restriction might well be enforceable, that having an architectural committee is permissible, and that people who buy into the unit would know that they were accepting that kind of restriction. 8, over on page 568, no smoking of cigarettes, cigars, or other tobacco products, etc. Courts have upheld smoking bans in common areas and in places like balconies or patios where it might affect other people. And there's even some case law that's upheld bans on smoking in individual units on the theory that it still might create secondhand smoke that would affect other people in the complex or building. So, you know, nothing definitive on some of these. You know, they're all subject to argumentation, but just an illustration of the kinds of restrictions you might run into and the kinds of considerations that might affect a court thinking about whether to allow their enforcement. So that is the end of our discussion of Chapter 10. Next, we will move on to Chapter 11 on zoning.